everyone, and welcome to Money and You, an initiative of the Financial Services Council that aims to boost your financial confidence and well-being. Today, we're going to be talking all about wills, what they are, why you should get one, when to get one, and what goes into one. Now, full disclosure, I don't know very much about this topic, but luckily I have an expert here with me today. Kellie McKinstry from Trustees Executors is here to answer all my questions. So I'm going to be learning along with everyone else. So welcome, Kellie. It's great to have you here.
Thanks, Carissa. Thanks for having me.
So let's get straight into it. What is a will?
A will is a legal document which sets out what you want to happen to your assets when you die. It can include lots of other instructions, say, for example, what sort of funeral you'd like to have, who's going to be guardians for your children, what sort of arrangements you'd like to make for any pets you've got, and who you'd like to administer the whole process.
When we're talking about assets, what exactly do we mean by that?
So your assets is really anything that you own. So it could be financial assets like your bank accounts, your KiwiSaver, any investments that you might have, or it could be your home or properties that you own, or it could just be things like your diamond ring or your picture of a boat that's up on the wall.
Okay, so it could be things that not necessarily a house, but so for example, I don't own a house, but I have investments. I've probably got some things that are quite special to me. So it also includes stuff like that as well.
Absolutely. It doesn't necessarily have to be things that are monetary value. It could be things that are passed down through your family for generations or that have sentimental value. Mm-hmm. Also, you might have life insurance, which might not be worth anything at the moment, but when you die, it'll be worth something to your estate and for the people who would like to benefit.
A will is something that I guess to me, it seems quite scary almost, like something I almost don't want to think about. I don't want to think about, the time that I'm going to die and all of these things, but hopefully I've got a few years ahead of me. Would you recommend that someone, in their sort of 20s or 30s should start thinking about it now, or is it more for sort of older people that are in that later stage of life?
That is something that you should be thinking about, whether you're 25, whether you're 55. Let's face it, nobody really wants to think about what's going to happen when they die. But if you've got any assets, if you've got a partner, if you've got children, if you've got KiwiSaver, if you've got life insurance, maybe you're going to be receiving an inheritance. If you own a home, those are all things that should be triggering you to start thinking about your asset planning, your estate planning, which includes making a will.
Mm-hmm. So in other words, it's always a good time to start thinking about a will, no matter what age you are.
Absolutely. And, the process of making a will is a lot easier than what people think.
If someone wants to get started and create a will, what's the process and how easy is it to actually make one?
Well, the process of making a will is usually quite straightforward. It's a really important document, so it is important to get it right. So I would always recommend getting professional advice. There are a number of options. You can now complete them online. You can get a will kit, but these options are only really appropriate if your will is really simple. So generally, I think it's an important enough document to have that you should get the right advice. And this would involve meetings or meeting your advisor, whether it be a solicitor or a trust manager, and just talking to them about what your circumstances are, what your plans are for your future, what assets you have, who you want to benefit from your estate. And based on that, they'll give you some advice and prepare a document for you that's going to suit your needs.
And how long does that process typically take? Is it a case of you have, say, if you are doing it through a solicitor or an advisor, is it one meeting with that person, or does it take, a little while to get things sorted?
So usually it would take 2 meetings. The first meeting would be the initial discussion about what your objectives are and what you want your will to say. And the second meeting would then be after the person had prepared the will for you to come in and sign your will document. And it's very important that your document's signed correctly. So the law says that your will has to be signed and dated, and it must be signed in the presence of 2 witnesses who can't be beneficiaries of your will, and they shouldn't be people that are related to you in any way either. So for your will to be validly signed, it's very important that it meets those criteria. And then it's also really important that your will's kept in a safe place. And then I also always tell my clients to let their loved ones know that they've made a will and let them know where it's held.
Right. So how does that process work? If you're doing your will online, you mentioned that was something that you are able to do these days if it's quite a simple will, in terms of getting people to sign it and witness it and all that kind of thing. Is that still possible when you create a will online?
Yes, depending on which company you use to create your will, often it will generate a document which then just needs to be signed and witnessed. As I said, anybody can make a will. It doesn't have to be a lawyer. It doesn't have to be a JP or Justice of the Peace.
Yeah.
An individual can do it as long as they're not, preferably not related to you or not benefiting under your will.
Mm-hmm. Now, you mentioned putting your will in a safe place once you've created it. And I'm just wondering, do you need to update a will? Is it something that once you've created it, you put it in a safe place and then it's done, tick, move on to the next thing, don't look at it again until you need to? Or do you need to actually go back and make changes to it later on?
Yeah, well, in the first instance, it's great when you have made a will. Well done for getting your will in place. But it is kind of a living document because throughout your life, your circumstances are going to change. You might buy or sell houses, you might get married, get divorced, you might have children. Some of your beneficiaries might actually pass away. You might win lotto. All kinds of different changes could happen in your life. And it's really important to regularly, even once a year, just turn your mind to whether, hey, this has happened this year. Maybe that means I need to update my will. Gee, I better get it out and have a look at it, see if I need to change anything, make sure it's still relevant to my life. So it's not really a set and forget kind of thing. Mm-hmm. A lot of people don't realise as well that if they get married, it means their will's no longer valid.
Really? Okay, didn't know that.
Unless you make your will in contemplation of getting married to a particular person, then it will still stand. But often people don't realise that if they've got married, their will is no longer valid.
Right. So if you get married, that should be on your to-do list as well as planning your wedding.
100%.
Update the will.
Definitely on the to-do list. Yes.
And I'm guessing also if you have a kid and start a family that would also affect, because then suddenly you've got a child that you might want to include in that will, right?
Yes, that's right. Not only you would want your child or children to benefit from your estate, but also it's really important that you take the opportunity to think about who you would want to be responsible for the upbringing of your children. So to name guardians in your will, it's a real opportunity for you to have your say and not just leave it up to the court to decide who's going to look after or raise your children. And it's important that your guardians are able to instill in your children the values that you would have wanted them to have. So, for you to actually appoint guardians in your will is a really important thing.
Let's say, like, worst case scenario, if you just never got around to making a will, and suddenly, something really unfortunate happened and you passed away. What's the worst case scenario, the worst thing that could happen as a result of not having any sort of will whatsoever?
Unfortunately, this is not uncommon. Not enough people in New Zealand have made wills and planned for what's going to happen if they pass away. If you don't have a will, or if your will's not valid, it means the law actually sets out who's going to receive your assets, your estate when you pass away, and it might not be what you would have wanted. For example, situations where perhaps you're in a relationship and you've been in a long-term relationship for many years, but you never updated your will to include your new partner, or you didn't make a will that included your new partner. Perhaps if you have children and a partner, things could get a bit tricky, especially if those children are from a different relationship. If you don't have a will, it's referred to as dying intestate. And that means that a few things will need to happen. One is that somebody will need to apply to administer your estate. So they need to file an application in the court. Now, this person who's looking to administer your estate might not be the person you would have chosen to manage that process. In addition to that, as I previously mentioned, your assets or belongings may not go to the person or people that you wanted them to go to. It's usually a lot more expensive in terms of legal process and administration as well, because the relationships of anyone who might be entitled to benefit from your estate needs to be proven legally, and this is usually done by getting evidence from births, deaths and marriages, or in some cases you need to a genealogist or a private investigator needs to be hired to find people in order to trace those family records.
Mm-hmm.
So that can cost a lot of money. I would also say that if you make a will, it kind of provides a bit of a roadmap for your loved ones and tells them what you want to happen. If you don't have a will, often they don't know. I've dealt with estates where there was no will, or there was a will didn't have any funeral instructions in the family, or the friends didn't know what the person would have wanted, and it causes a lot of stress on top of the fact that people are actually grieving. So, just think of it as a way you're also helping out your loved ones by putting a will in place and letting them know what it is that you would wanted. And it can give them some peace of mind as well to know that your wishes are being carried out.
Yeah, that's something I didn't actually think about. I think, and I'm sure I'm not the only one, you kind of think, okay, a will, it's for me, but it's actually more for other people, isn't it? And
well, it can be, and families are complicated these days. It's a lot less common that we just have the usual nuclear family. A lot of people, they don't get married. Some people are in more than one relationship. They have children from different relationships. We have blended families. People have family trusts. There's all kinds of aspects that can come into play which complicate matters.
Now, I also wanted to ask, there are a few terms that are used that I've, in relation to wills that I've read. Trustees, beneficiaries, executors. What do some of these terms actually mean? Like, what is a beneficiary when we're talking about wills?
So a beneficiary is a person, or it could be an organisation or a charity. It's whoever is going to receive something under the will.
Okay.
So it could be your sister who's going to get you a toy your child who's going to receive a gift of $100,000 from your estate. The beneficiaries, whoever is going to receive something under the will.
And how about executor? What does that refer to?
So the executor is the person that's responsible, or sorry, it doesn't have to be a person, it can be a trustee company, who's responsible for administering the estate. So what that involves is administering the assets, so collecting the assets of the estate and distributing them out, so paying them out or transferring to the people who are named in the will as the beneficiaries. Technically, also, the executor is responsible for dealing with the funeral, making sure the debts are paid, dealing with any tax liabilities. So usually in your will, you would say, I appoint so-and-so as my executor and trustee. So I'll just explain what executor is. Sometimes estates are held in trust for a period of time, and that could be if, say, for example, the beneficiaries of the estate were children and they were too young to actually have the estate paid out to them. So that means that the estate has to be held until they're old enough. So at that point, the executor then becomes a trustee, and the trustee's job is to hold the estate for those children until they're old enough to receive it. So that's why they say in the will, I appoint so-and-so as my executor and trustee.
Right. Okay.
This covers off both of those points.
Cool. Okay. Thanks for clarifying that. I'm learning a lot. What are some of the misconceptions that people have around wills? Like, I'm sure that, you get lots of questions from people all the time as part of your job and read and see things. There's certain things that people don't get quite right or kind of don't understand as well as they should.
There are a few things that I've come across quite regularly. As I mentioned before about your will becoming invalid if you get married and you haven't made your will in contemplation of marrying your partner, that usually surprises people. They are quite often surprised to hear that the will that they made 20 years ago before they met their current spouse is no longer valid anyway. Another misconception, I guess, is that, it doesn't matter if I haven't got a will because it's just going to go to the kids or it's just going to go to my wife. It's not necessarily the case under the law. Other misconceptions might include who can witness a will. So I've sort of read some things online recently that some people think it has to be a lawyer or a JP that can witness a will. That's not true. Actually, anybody can witness a will, as long as you're an adult and you are not going to receive anything under the will, or you're not married to or a partner of anybody who's receiving something under the will.
Mm-hmm. Okay. All right. I've learned so much today. Thank you. Is there anything that you'd like to leave people with? Any advice or any suggestions for what people like me could do? I
think these days it's a lot easier than what it has ever been to get a will in place. I've been working in this industry for a couple of decades now, and I've seen what happens when people haven't made a will. I've seen how hard it can be on their family or their loved ones that they leave behind. I've seen the arguments that can come up as well. I think it's probably a good, I wouldn't say a habit, but it's a good thing to get into your mind. Is like, you update your insurance every year that you have. If you've got a property, you're reviewing your mortgage. You're trying to save money in a bank account. all those sorts of things that you're looking at on a fairly regular basis, and also thinking about when your circumstances change. If you can just sort of make it your habit to sort of say, actually, maybe I need to think about a will because this has happened, or, I've got KiwiSaver, well, I need to think about getting a will. And then, something changes, or maybe I need to update my will. I think it's just a really good habit to get into. As part of your general financial life planning. And it's, like I said, it's easier now than it's ever been. I think a lot of people sometimes feel a little bit worried about the process because it is kind of thinking about what's going to happen when you die. But often after sort of had a meeting with them and talked about it, they often get told, oh, actually, that was a lot easier than I thought. And it's done. You've got a will in place. So I would just say, go ahead, have a look online. If your circumstances are simple, if not, just pick up the phone.
It sounds like one of those things that you kind of put off or you don't want to think about, but once you actually do it, it's done. And then it's just a case of updating it from time to time with these, if there's a big life event or something changes.
And often people say to me, oh, it's always been in the back of my mind that I have to do it, but I just never got around to it. And now I wish I'd done it sooner, and now it's good to have everything in place, and it gives a bit of peace of mind once it's done to know, that you've got things sorted.
Fantastic. Well, thanks so much, Kellie. As I said, I've picked up a lot of things and learned a lot, and those misconceptions that you talked about particularly were really interesting. There are some things there that I definitely didn't know. So hopefully those watching or listening have also learned a lot today. And thanks again for joining us.
You're so welcome. Thank you for having me.